Understanding Colorado's modified comparative fault statute. In personal injury law, the interplay of liability and fault allocation is a critical aspect that shapes the outcome of legal cases. One pivotal legal doctrine that holds significant sway is Colorado's modified comparative fault statute. This statute, rooted in the principles of fairness and accountability, governs the distribution of damages in situations where multiple parties may share varying degrees of fault. What is comparative fault? Before we dive into the specifics of Colorado's modified comparative fault statute, it is essential to establish a solid foundation in the concept of comparative fault. This legal doctrine serves as a cornerstone in personal injury litigation, aiming to apportion responsibility for an accident or injury amongst all involved parties. Comparative negligence is a pivotal legal doctrine that seeks to equitably apportion responsibility for accidents or injuries among the involved parties, taking into account their respective levels of negligence. This stands in contrast to contributory negligence, which bars any recovery for the plaintiff if even a minor degree of fault can be attributed to them. In Colorado, the doctrine adopts a modified form of comparative negligence, which means that regardless of the plaintiff's share of blame, they retain the right to seek compensation, albeit adjusted according to their level of fault. In a motor vehicle collision claim, comparative negligence acts as a defense to the injured person's claim for damages. The insurance company for the at-fault driver may argue you share some blame for your injuries and reduce settlement offers. Comparative negligence is also a legal defense the at-fault party can allege in a lawsuit to reduce or eliminate the amount of money you can receive at the end of a trial. Types of comparative negligence. Colorado employs a modified comparative negligence system, a stance that distinguishes it from states adhering to the pure version. Under the pure system, a plaintiff can recover damages even if they are predominantly at fault, with their compensation diminished proportionally. This implies that if a plaintiff is found to be 80% at fault, they can still claim 20% of the awarded damages. In contrast, states utilizing a modified comparative negligence approach like Colorado only allow recovery if the plaintiff's share of blame falls below a certain threshold, often set at 50%. The evolution of comparative fault. The evolution of comparative fault as a legal doctrine can be traced back to the mid-20th century. Prior to its establishment, a more rigid legal framework known as contributory negligence was in place, barring plaintiffs from recovering any damages if they were found even slightly at fault. Comparative fault represented a paradigm shift, ushering in a fairer and more nuanced approach to assessing liability. The doctrine of contributory negligence finds its roots in early English common law, where it was initially applied strictly and without leniency. In its original form, even the slightest degree of negligence on the part of the plaintiff could bar them from seeking any damages. This rigid application of contributory negligence persisted for centuries, leading to contentious debates within legal circles. Critics argued that it placed an unjust burden on plaintiffs, often preventing them from obtaining fair compensation, even in cases where the defendant's negligence was the primary cause of the injuries. Colorado, like many states, underwent a significant transformation in its approach to contributory negligence. The legal landscape shifted towards a modified form of comparative negligence, allowing plaintiffs to recover damages even if they shared some level of responsibility for their injuries. This shift represents a more balanced and equitable approach to determining liability. It acknowledges that situations are rarely black and white, recognizing that both parties may bear some degree of fault. Under this modified system, damages awarded are proportionally reduced in alignment with the plaintiff's level of responsibility. Colorado adheres to the modified comparative fault system, a legal framework that introduces its own set of rules and guidelines. According to this statute, an injured party can seek compensation as long as their degree of fault does not surpass 50%. However, if the injured party's responsibility is found to be 50% or more, they are prohibited from recovering any damages. The role of legal representation. Navigating the intricate landscape of Colorado's modified comparative fault statute can be a formidable task. Thus, enlisting the expertise of a seasoned personal injury attorney becomes paramount. A proficient Denver car accident lawyer can strategically construct a case, marshal compelling evidence, and adeptly negotiate with insurance entities, ensuring that you receive just compensation. When a defendant asserts a comparative negligence defense, it affects both insurance negotiations as well as litigation. If the at-fault driver's insurer believes you are partially at fault, they will adjust settlement offers down to reflect that. Often that requires filing a lawsuit to pursue a fair outcome for your case. The lawsuit is more complex because you and your attorney must present a compelling case for your damages but also defend your acts. As experienced auto accident lawyers, we understand these tactics and prepare to pursue the strongest case from the outset. Your lawyer will engage the insurance company early in discussions to determine if they believe there is shared fault and begin working to gather evidence and determine the liable parties and their share of liability for your injuries. Your personal injury lawyer will also determine whether litigation is a superior option for your case and prepare to take your case to trial if necessary. Insurance companies often allege shared liability for your injuries as a way to chop down settlement offers and convince you to settle for less than you deserve. If they know you do not have a personal injury lawyer on your side, they know the likelihood that you will overcome their allegation of comparative negligence is extremely slight. By hiring an attorney, the insurance company knows your case is serious and you take it seriously. Conclusion. In conclusion, Colorado's modified comparative fault statute stands as a cornerstone in personal injury law, shaping the trajectory of cases involving shared responsibility. A profound comprehension of this statute is indispensable for anyone embarking on a personal injury claim within the state of Colorado. If you sustained injuries in an accident caused by someone else's negligence, contact our experienced car accident attorneys today to discuss your case and how we can help you recover fair compensation.